and it's also being live streamed on YouTube as well, so it will be accessible there afterwards too. I would just like to introduce Arletta. She is a PhD student in Strathclyde Law School in both the Centre for Internet Law and Policy and the SCILP Centre for Competition Law, and is doing some really great research that she's going to be telling us about now on the interaction between competition, data protection, and privacy. So she will talk for about half an hour or so. We'll have some time for questions, and we will also aim to finish up pretty promptly at 1 o'clock UK time. So over to you, Arletta.
Great, thank you very much for inviting me so warmly and giving me such an opportunity to discuss some of my research. The research I'm going to speak about today is based on a book chapter I've contributed to, a book entitled Personal Data Protection in European Union, and it's by IG Global Publishing, edited by Maria Tsarou. So I'm going to share my screen and switch off the camera as well so you can see the presentation I've prepared for you. So the name of today's presentation is the Data Protection, Privacy and Competition Law, and I'm going to briefly define the relationship between privacy and competition. As starting with a wee legal background, like we know that lack of standardized approach towards the data collection and privacy assessment and controversy surrounding the recent investigation indicate the challenges that are not initiating the anti-competitive scrutiny. And of course, with any lack of those relationship and I mean lack of any certainness, we stuck with a question whether privacy can indeed help to support competition law assessment or might just not do anything at all. So before we briefly start talking about the relationship, excuse me, I think I froze. Excuse me, yeah, it's working, sorry for that. So before we start anything about talking about what is the relationship between competition law and privacy and what we know and what we don't know and how competition law and privacy can impact each other, we need to start briefly talking about the foundation. So EU law by its foundation aims at promote peace, well-being of citizens, freedom, sustainable and economic development, and the rules adopted on competition law and data protection reflect on the fundamental goals under the Treaty of Functioning of European Union, and there are technically two separate legal bases. So starting for competition law, the competition law pursues many different aims, including the protection of market structure, economic freedom, consumer welfare, and the protection of efficiencies. And all the goals for EU competition law are enacted in from Article 101 to Article 106 of the Treaty of Functioning of European Union. And they mainly aim at prevention or distortion of competition law or abuse of dominant position. The EU competition law applies to any economic activity that might affect trade between member states. Within the digital economy, the emphasis is usually placed on Article 102, which prohibits the abuse of dominant position in a relevant market. And an abuse of dominant position is understood as taking forms of exclusionary abuse and exploitative abuse. So briefly speaking, the exploitative abuse refers to an action which harms consumers. In most cases, the victims were companies and not the end consumers, and includes application of extensive prices on unfair discrimination. And on the other hand, we've got exploitative abuses, which refers to an abuse by which the market structure is damaged and includes form of time, bundling, refusal to supply, market squeeze, and predation. I'm going to say something more about those two abuses while we'll be speaking about the latest Facebook case, but just in a couple of more minutes. If we move forward, there's another issue. We've got the data protection law. I'm sorry, again for all the mistakes. So the data protection law is quite extensively protected by the EU law. And we've got a couple of the primary and secondary documents which which protects the data protection. So the starting point is Article 16 of the Treaty of Functioning of the European Union, which says to be the basis of the EU data protection law. We also got a Charter of Fundamental Rights, where the Article 8 recognizes personal data as a proactive right, which goes beyond the protection of individuals against a state intervention. And by the virtue of Article 8, individuals might expect the information to be processed by anyone, including the states, and allow lawful, fair, and transparent for individual manners. And lastly, we've got the General Data Protection Regulation, which been enacted in 2018, and recently we celebrated its second anniversary, and it's an instrument which governs how companies are allowed to process personal data. By Article 4, subsection 2, the GDPR defines the processing as involving any activity that might be undertaken about personal data, and the personal data is defined as acquired information relating to a natural person, which allows them to be identified, and that usually allows to might be IP location or any other personal information. Under the GDPR regime, the consent plays a vital role, and the consent needs to be informed, specific, unambiguous, and clearly given. And a data controller could only process personal data under lawful basis, which are set in Article 6, subsection 1 of the GDPR, and includes consent, public interest, legitimate interest, and contract. The GDPR enacted the supervisory power and strengthened the protection of personal data and simultaneously the protection of users' privacy. So having defined these two separate legal bases, we now need to consider what is the relationship between those two within the EU legal order. Many calls it as a confusing relationship, because it's itself the digital economy has itself resulted in a rise of disruptive technologies, which might produce some social benefits. Where if we consider the EU legal practice, we could see three different phrases which kind of try to bring forward how the relationship shaped between all these years. So primarily starting the interplay between competition law and data protection rules were stressed to be outside the scope of competition law. And it was said in 2006 in the case of ASNA. And at the same time, we've got also a vertical merger of TeleAtlas and TomTom. And again, the Commission didn't raise any data issues and kept a prudent approach and excluding data protection argument in the assessment. With an increased appetite for data, the subsequent enforcement abandoned isolation of data protection principles from anti-competitive assessment and indicate a potential parallel pathway between competition law and data protection. For example, in a merger of Google and DoubleClick in 2008, we might see some sort of an attempt to define the parallel path between those two legal orders. Yet the Commission adopted the ASNF ratio and concluded the case without prejudice to the obligation imposed onto the parties by community legislation concerning the protection of individuals and the protection of privacy about the processing of personal data. So, but nevertheless, we consider the case further. The Commission was quite conscious that the acquisition of user data might result in target advertising and restriction of privacy rules. Potential anti-competitive conduct concerned exploitative and exclusionary abuse, diminishing consumer experience and lessening competition on a relevant market. Yet furthermore, a more mature approach was presented in the case of Microsoft LinkedIn, which was another merger case. The Commission relied on the user's privacy protection to assume the impact of combining the two companies' databases. And interestingly, the decision referred to the GDPR at the time, yet at the time of the case, the GDPR was still not enacted. It was just a couple of months before. So the announcement of the GDPR was set to empower individuals with control over their data and limit Microsoft's ability to access and process personal data of the users. Yet the Commission focused on securing the competitive process and did not provide any guidance or data protection within the competition law sphere. So hence there was no optimal consensus as to how to evaluate the data and the EU competition law. And of course, it's been apparent that the EU competition law supports the prevailing approach and assesses decisions involving personal data through the spectrum of protecting competitive balance in a hypothetical market. Yet moving forward, recently we got some sort of attempt to recognize the data as a component in the competition sphere by the EU member states. And we've got quite many examples to discuss, with the Facebook case being one of the most notable example which sparked up the debate. The German Competition Authority launched an investigation against Facebook in March 2016. And the investigation was launched purely because the Facebook was suspicious to abuse its dominant position through imposition of unfair terms and conditions, which allowed platforms to collect and use user data from Facebook-owned platforms such as Instagram or WhatsApp, and through the use of Facebook business tools, which is used by any third-party websites or apps. The decision was adopted last year in February 2019. And when we speak about the defining Facebook case, there's a couple of elements which needs to be discussed, of course. So starting the point, we've got the market definition, then we're going to speak about dominant position, abuse of dominant position, and lastly, I'm going to mention something about the remedies. So in defining the market, the German Competition Authority concluded the market as a social network market in Germany, with about 95% of the social network users on a daily basis. And while further assessment, the relevant market was defined as a social media market in Germany and recognized the Facebook as a multi-sided platform. The German Competition Authority, based on the criterion for demand side and submission, excavated two sides of the market, with the first one being the protection from the perspective of private users and based on a terms of application, price and characteristic, and the opposite side was the private end users market, which was users that used Facebook for free. And of course, the non-price assessment of Facebook was not seen as a problem for Germany, because the German Competition Act states that the market assumption would not be invalidated due to the free products being provided. And of course, having considered that there was 95% of the daily social users, and of course, there weren't any other competition available on the market, because, for instance, the only potential platform that could have been compared with Facebook was Google+, and Google+ has been shot. The Facebook stands still and was the only platform being so distinctive from platforms such as LinkedIn, which is a professional platform, or Instagram, which is technically a platform to put your picture there. So based on further assessment, the Facebook was said to be having a dominant position, and the Bundeskartellamt, the German Competition Authority, looked further at how to manifest a clear market power. So when we speak about the abuse of dominant position, we've got, like I mentioned, we've got two options: the exploitative theories of harm and exclusionary theory of harm. While we discussed the exploitative theory of harm, the Bundeskartellamt was quite concerned with the two antitrust issues. First of all, was said to be accumulation of data, which allowed Facebook to entrench the dominant position, and then it was a single catch consent to all the Facebook users. And the above were deemed unfair under Article 102 of the Treaty of European Union. And while assessing the exploitative theories of harm, we've got the German Competition Authority saying that Facebook terms and conditions allowed for a wide data acquisition for a variety of sources and subsequently merged the gathered data together. The exploitative abuse include a prohibition of unfair trading condition, unfair pricing or predatory pricing, and it remains accepted that the price or trading terms might be unfair to its effect on competitors. Yet the case affirmed that excessive trading conditions and prices could amount to abuse of dominance due to its effect on consumer welfare. So for many, the Commission practice is indeed capable of supporting that privacy consent could be a parameter for anti-competitive abuse under Article 102 of the Treaty of the European Union due to its disproportionate nature. Today, in the case of exploitative trading condition, we've got the Saban, which considered whether the Belgian collecting society abusing its dominant position by demanding authors to give up their copyright in the name of the society, and the case pointed that the fairness of the clause required an assessment of all relevant interests, which is necessary to achieve a proportionate assessment ensuring a balance. Furthermore, based on another case, the Tetra Pak 2, the Commission raised an interesting point regarding the applicability of the proportionality test in any exploitative abuse assessment. And according to the Commission, such clause imposed an additional obligation which have no connection with the purpose of a contract and which deprived the purchasers of a certain aspect of his property rights. So comparing these two cases, the Facebook case, the German competition authority deduced that the Facebook privacy policy was not required to offer social networks to its user, not for monetizing the network for targeted advertising. And in the Facebook case, I agree the GDPR infringement might constitute a basis for exploitative abuse. Yet this approach would probably require a case-by-case analysis as the meta infringement of the GDPR would not amount to exploitative abuses. And on the other hand, we also have the exclusionary theory of harm, and the German competition authority has not directly mention any references to exclusionary theory of harm, yet on the closer assessment of the case, we might see there was indeed some sort of elements that might point also the exclusionary abuse. So within the ratio of post-Denmark 1, we've got that the Facebook conduct could be considered as being exclusionary since the conduct amounted to the detriment of consumers, on consumers hindering and maintenance of degree of competition existing in the market and the growth of the competition. Today, in the health competition or competition on merits would require an undertaking to obtain data by the voluntary consent as per the GDPR. And any effect on unlawful conduct by the dominant undertaking would have a detriment effect both on consumer competition and in principle be seen as abusive. The restriction of the effective competition process might result in a consumer harm as well as foreclosure of competition on the social media and the online advertising markets. Today, with Facebook GDPR infringement attached some sort of competition weight as a poor privacy protection might involve a lower quality, higher prices, or reduction of innovation. Yet the competitive weight of Facebook conduct would have a foreclosure effect rather than simply relying on GDPR infringement. Hence, generally speaking, all the elements of the abuse of dominant position must be identified to impact the GDPR infringement on an anti-competitive assessment. It might become acceptable that unlawful acquisition of data might have an impact on the barriers to entry, make it difficult or indeed impossible. And general data asymmetry might result in hindering the competitive growth to a certain extent. The privacy concern and the competition principles might have exclusive competence. However, this could be only effective as a further indication of competitive abuse and not by any means be seen as something that will absolutely revolutionate competition law. And lastly, talk about the remedies. The German Competition Authority ordered Facebook to adapt its data policies to 12 months to implement the changes. And Facebook could no longer combine the data acquired from Instagram or WhatsApp or different Facebook-owned platforms with the Facebook user's account without the voluntary consent. Yet the appeal of the case is still waiting, and we're still going to see what the future is going to bring in this respect. We've been left in quite of a perilous not knowing, is there a way forward, and does the case really brought any certainty or caused even more problems? So if Facebook, for many, Facebook was not really seen as a case that attempted to connect the competition law and data protection, with many scholars arguing there was a lack of clarity or lack of causality between the data protection infringement and the competition law, and with many also claiming that the case indeed abandoned the defined rules of a competition law with how to really look at the market functioning and what is the real value of data protection within the competition law. And we also got the higher regional court of Düsseldorf raised serious doubts about the case itself. So yet there was not the end. Has been some attempt throughout the European Union to try to look closer at the relationship between competition law and data protection. And we got in 2018, the French Competition Authority published a report on the sector inquiry into online advertising, and the report came out 2 months before the GDPR came into force. The report identifies possible competition concerns in online advertising sectors and mapped out that the sector is characterized by fragile competition equilibrium, since there were only 2 significant global players in the market, which was Facebook and Google. To picture this efficiently, the zero-price platform collects the user's data and then change the data to advertising services in return for profit, which permits a zero-price platforms to innovate. And also the French Competition Authority in their report noted that in consequences, these players benefit from competitive advantages, including vertical integration of advertising sectors and data analysis. Hence, the report in itself added that the multi-dimensional relationship might have a potentially negative impact on the other market players, and overall market growth might be available only to the players with an access to the best quality of data and algorithms. Yet, although the report might be viewed as disregarding the privacy concerns in competition legal regime, the French Competition Authority approach indicated an apparent priority to fight with anti-competitive data-related behaviors. So another attempt to look to define the relationship was seen as a joint report of French and German competition authorities. And they report briefly analyzed there is a case-by-case examination of competition law to assess the suitability between data and the competition law could be required. Yet this report might be criticized due to the lack of predictability, as well as might be the case that the national law could have a stricter competition rule rather than those imposed by the EU law. And furthermore, even more uncertainty could be created because the EU Commission pursues a digital single market strategy. So interestingly, any GDPR infringement does not automatically imply on a competition law infringement. In the Facebook case, the German Competition Authority justifies Facebook anti-competitive behavior by the GDPR. Yet, like I mentioned in the previous slides, there was another case by the German Regional Court of Düsseldorf, which raised a serious doubt regarding such assessment, as apparently the German Competition Authority focused too much on data protection law and disregarded the applicability of the antitrust law. And arguably, privacy is a complex matter from a competition law perspective and is clearly beyond the scope of competition law to assess potential public infringements. Crucially, there are difficulties in ascertaining what is really the competitive level of privacy. The acquisition of data is an important parameter for a business model, as the court stressed, and it stressed that the Facebook business model is based on offering a free service which is financed through tailored advertising. Importantly, consumers are not obliged to use Facebook, as if they are unsatisfied with the platform, they can always change it. And of course, the consent they give to Facebook is solely voluntary. Yet, realistically, the users are just indifferent. They do not wish to devote the free time and effort to read the very lengthy, full of legal jargon terms and conditions. Hence, the court concluded that there was no evidence that the consent was obtained through pressure or coercion. However, consumer welfare is a recognizable goal of competition law and potentially, and arguably by many, might not be seen as the most important one. And furthermore, if we look at the EU merger assessment, there could be room for a more dynamic policy approach making obtained from taking data consideration into merger cases. Potentially reason to justify such action is an inability to extend competition law to direct assess the privacy law pitfalls. Besides, privacy consent could be associated with informational asymmetry rather than a market power. Hence, it is another reason why competition should not intervene in privacy law. The debate around the data relates only to the common cliches, arguing that the data is a factor contributing to market power, increasingly market transparency, and acting as a competitive instrument. The competition law, on the other hand, should also not be seen as instrumentalized as it beyond the scope of competition legal enforcement to broaden any macroeconomic agenda. And additionally, the German Facebook case has not developed any idea further analyzing privacy concerns as a mere additional feature in an antitrust assessment, which asserts Facebook abuse of dominance. The German Competition Authority proceeding might thus be seen as targeting all data-run companies, essentially since data is an important parameter on their business models. Yet, if we also look at the German Competition Law Authority case against Facebook, we might see that there could be a room for granting a huge power to competition authority, which could consider different policies when assessing anti-competitive conduct dominance. And since under the Regulation 1/2003, the national competition authorities have become a prior enforcement of the EU competition law, and it has been evidented that since 2004, the Commission has only adopted 15% of the enforcement decisions. Therefore, this could have created even more ambiguity, as competition enforcement should only be seen as protecting competition processes within the relevant market. And such an argument could be supported by an argument of non bis in idem. There shall be no legal action put motion twice over the same conduct of action. Hence, no consensus remains as to the optimal method of evaluating data protection and the competition law. And it's apparent that the EU competition law supports the prevailing approach and assesses any decision for the spectrum of protecting a competitive equilibrium in a hypothetical market. Nevertheless, the concept of privacy appears to be multidimensional, dynamic, and therefore requires a careful consideration of all dimensions and interests of the parties on a relevant market. Hence, we now going to question the heart of my research. What is the privacy in the sense of competition? We've got a couple of points to mention. So firstly, we're looking at the privacy as a competitive parameter. We know that the data has become a key input for online services providers as a key for revenue and innovation. Yet the data acquisition does not immediately result in anti-competitive conduct. However, on an unprecedented scale, it could put end users into danger. Although EU competition agenda might be applied in other policy considerations, which include consumer protection, investment, transportation, privacy concerns, were noted to be outside the scope of the EU competition law. Considering the Facebook case, the privacy consent acted as furthering the argument based on the established principles of the competition law. Therefore, there could be situations when privacy consent and the competition law could not act mutually. So, for example, if an undertaking breaches a data protection law, they might do it without breaching competition law too, because they might not have a substantial market share. Hence, the references to the privacy could be irrelevant for the competition law. And in addition, there's a consensus that the scope and measurement on efficiency plays a crucial role in competitive assessment. The efficiency defense used as a defense for Article 101 of the Treaty of Functioning European Union, which prohibits any anti-competitive agreement, was imposed to protect market competition as a means to ensure efficient allocation of resources. However, there's no alternative defense recognized under Article 102 of the Treaty of Functioning European Union. Categorically, proposition violating Article 102 might be mitigated if an abuse contributes to an increase in efficiencies. Yet in a wide spectrum, the protection of effective competition autonomy bears an important implication on the digital economy. The data acquisition might offer a mandate for intervention without considering the effect of consumers, which potentially enables for an efficient consideration on the effect of the digital market. Hence, it might be difficult to assess the competitive level of privacy, and interestingly, data protection could introduce a baseline for individuals' protection, which competition law could further enhance. These two distinct fields of law share normative features and are concerned with the market power asymmetries, simultaneously protecting consumer welfare throughout the data processing circle and against abuse of undertakings market power and deviates their preferences. The recently published report by the EU Commission law on this topic did not put also forward any solution to weigh up the privacy, the data privacy element as a part of competitive assessment, and merely indicated that it was too early to initiate any competition law enforcement changes. And again, potentially a case-by-case analysis could be required to weigh up the importance of the data as an element lessening competition law or an extension to already existing theories of harm. The other point to mention is that privacy as innovation parameter. Innovation might be seen normatively positively if it allows for a more efficient fulfillment of consumer preferences, which might lead to the utility increase. Innovation stimulates dynamic markets and enhances consumer welfare, which in turn might offset diminishing the marginal return. In innovation, the data protection assessment, we've got the two hypotheses, the Schumpeterian and Arroyan hypotheses, playing a very important part. The former understands market concentration to enable the internalization of the reward resulting from the effort of innovation, which potentially might create negative correlation between innovation processes and the competition law, as supporting creative destruction where the old technologies are replaced by the new one, whereas the Arroyan hypothesis understands the competitive pressure as an innovation parameter. Therefore, these two U-shaped relationships suggest that the innovation increase results in a competitive pressure, whereas a market power decreases investment and innovation. The uncertainty surrounding the data protection within the competition legal order calls for very cautious interventions due to difficulties to apprehend the quickly changing environment on the digital market. Yet on the other hand, there must be some reasonable prospect of being rewarded for the innovation endeavors of the companies, which could result in a higher profits or temporarily increase in the market power. Furthermore, the services and apps which are offered at zero cost must have enough profit to keep the innovation going on and to make the services even more attractive for the already existing customers or the new customers. Therefore, there could be reasonable scenarios including two packages offered to the end users respecting their internet autonomy. So firstly, there could be a package imposed which would based on the zero price, and hence the users would voluntarily consent to the data acquisition. The data will then function as an asset and would enable services provided to sell all the data to third parties, and in this respect, a service provider would get a profit for selling the data, whereas the consumer could be subjected to the advertising. And the other package could be seen as being a subscription fee package where the users agree to pay some sum of money and then get no advertising, but again the platform will have enough of money to keep the innovation growing on. And lastly, we've got the privacy as consumer welfare parameter. And we know that the competition law and data protection are interchangeably influencing each other, protecting the market and consumer welfare. The ultimate goal of the competition law is to ensure the effectiveness of the competition in the internal market, which aims at increasing consumer welfare. Whereas the data protection law, customer protection, aims at protecting the effective exercise of consumer choice. In the light of the member state development, privacy could be only seen as an additional feature seeking to protect competitive specification, which include price, quality, innovation, and choice, and arguably could only indirectly influence the already existing competition law parameters. Privacy functions as a non-economic activity since it aims at benefiting all the members of the society. And within the digital economy, the concept of consumer welfare might be used to tackle the welfare effect on a numerous group of consumers, also comprising all members of the society, covering both direct and indirect consumers. Considering a price-centric method to consumer welfare, a distortion picture could be potentially presented. The digital market usually provides an ostensibly free for consumer service, hence equality forms an important competitive parameter. Bringing an example of a Facebook case, the distortion of privacy was seen as harming consumers, despite having no price effect. Hence, the privacy might enforce the range of not easy quantifiable varieties impacting on consumer welfare. And we also have the behavioral element attached to this, because the behavioral element supports an increase in the usage consumption, because the consumers are more likely to stay in the platform where their friends or family users are, and often they're unaware of maintaining competitive pricing because of the increased consumption. The changing economic landscape brings uncertainty to competitive pressure, with an emphasis being given on the normative scope of competition enforcement, mainly as to whether the EU competition law could be viewed as societal norm, also advancing the wealth. The objective of Article 102 are necessary for function of an internal market and consumers, and would terribly ensure the EU legal order functions well. The consumer welfare benchmark might be useful as addressing the competition law infringement effect on the consumers group, yet the social welfare might function as a separate stream to which different criteria applies. It was mentioned by the case of Albany in 1999. For example, Townley argued that structure of the EU treaties demand an assessment of the wider public policy concerns in the competition law. Arguably, it is beyond the scope of competition law assessment to look at the all potential public policy infringement. The data protection, which is designed to provide optional protection for personal data, might only act as a normative support which could guide indirectly competition law about the non-price parameters. Furthermore, the privacy protection acting as a part of a contract between the users and the platform provider might create potentially exclusionary and exploitative practices if the contract cost is unfair on the consumers. Hence, assessing this for the prism of a competition law, they might create new forms of theory of harms, which would require intervention, of course. However, the key issue lies in apprehending these claims within the established goal of the EU competition law. And undoubtedly, weighting the goals, values, theories of harm and economic analysis is a foundational proof to evidence on which the decision will be founded. And lastly, it is still deducible that the privacy consent might not revolutionize the competition law itself, but might only provide an insight into the anti-competitive activity. The established competition law rules are adaptable to provide adequate remedies to bring a competitive equilibrium on a relevant market. Hence, the mere privacy violation, which brings detriment of consumer welfare, will be answered by data protection or consumer welfare protection and not by competition law. So both data protection and the competition legal order will seek, of course, the advancement of the market integration and shall concert for the welfare of individual, with the consumer benefiting from collection in their data and a wide array of free services and content. As we still leave with an open question, can the data protection influence the goal of competition law? And based on all that what I've mentioned, it is very unlikely that there could be any drastic changes within the competition law to apprehend privacy concerns. Thank you very much for your attention.